Tonight, we drift softly into one of the coziest corners of adulthood: estate planning. Yes, estate planning. That warm, velvety topic that sounds like it should involve a manor house, a candlelit library, and a butler named Edwin, but actually involves things like beneficiaries, powers of attorney, and making sure your second cousin does not accidentally inherit your blender. So settle in, get comfortable, loosen your grip on the day, and let us gently wander through wills, trusts, healthcare directives, and the deeply soothing administrative reality that one day someone will need to know where you kept your important documents. Not to alarm you, only to relax you. This is not legal advice, and it is not specific to your situation. It is general information, softly presented, for educational and possibly sedative purposes. Take a slow breath in and out. Very good. Let us begin. Part 1. What estate planning actually is. Estate planning is the process of deciding what happens to your money, property, belongings, responsibilities, and certain personal decisions if you become unable to manage things yourself, or after you die. Which, when phrased like that, sounds dramatic. But really, estate planning is just thoughtful organization. It is the administrative equivalent of leaving a tidy note, a very detailed note. A note that says, in essence, "Hello, loved ones. If I am unavailable, please do not panic. Here is where everything is. Here is what I wanted, and here is who gets the dining table." Your estate is not only for the fabulously wealthy. You do not need a vineyard, a yacht, or a suspiciously large portrait of yourself hanging over a fireplace. Your estate is simply what you own and what you are responsible for. That might include your home, your car, your bank accounts, your retirement accounts, your furniture, your jewelry, your debts, your digital accounts, your sentimental keepsakes, and perhaps a box in the closet labeled miscellaneous cables, which no one has opened since 2014. Estate planning helps reduce confusion. It can reduce conflict. It can speed up administration. And it can make life much easier for the people you care about. It is, in a quiet way, an act of kindness. A paperwork-based kindness. The gentlest kind. Part 2. The Last Will and Testament. Let us now float toward the will. The last will and testament is one of the most familiar estate planning documents. A will generally says who should receive your property after death, who should handle your estate, and, if you have minor children, who you would want to serve as guardian. That person who handles your estate is often called an executor or personal representative, depending on the state. This is the trusted soul who agrees to do all the glamorous tasks of estate administration, such as locating documents, contacting institutions, paying bills, handling taxes, gathering assets, and filling out forms that somehow require both black ink and impossible patience. Choose this person carefully. You want someone responsible, organized, calm under pressure, someone capable of opening a filing cabinet without becoming emotionally overwhelmed. Your will can name beneficiaries. These are the people or organizations who receive what you leave behind. You can be specific. You can say who gets the house, who gets the jewelry, who gets family heirlooms, who gets the vintage record collection, and who, under no circumstances, gets the ceramic rooster you secretly hated but felt obliged to display for years. Without a valid will, the state's intestacy laws usually decide who inherits. And while the state is many things, it is not especially talented at knowing who should receive your grandfather's watch. A will may also help express your wishes clearly, but it generally does not avoid probate all by itself. And that leads us gently, inevitably, sleepily, to probate. Part 3. Probate, the soft bureaucratic fog. Probate is the court-supervised process of administering a deceased person's estate. Some assets pass through probate. Some do not. Probate may involve proving that a will is valid, identifying assets, paying debts and taxes, and distributing what remains to beneficiaries. It can be straightforward. It can be time-consuming. It can vary significantly depending on the size and complexity of the estate, the laws of the state, and whether anyone decides this is the perfect moment to revive a 15-year-old family disagreement. Many people seek to simplify probate or reduce how much of their estate passes through it, not necessarily because probate is evil, just because paperwork, deadlines, and court procedures are not usually described as soothing, unless one is making a video like this. And in this video, they are extremely soothing. Imagine probate as a long beige hallway with labeled file boxes and sensible shoes. Breathe in, breathe out. Excellent. Part 4. Assets that pass outside the will. A very important and often surprising point is that not everything passes through a will. Some assets transfer by beneficiary designation or title. For example, retirement accounts like IRAs and 401ks often pass to the named beneficiary on file. Life insurance proceeds often go to the named beneficiary. Joint accounts may pass to the surviving joint owner, depending on how they are titled. Payable on death or transfer on death accounts may go directly to the named person. This means your will is important, but it may not control everything. If your will says one thing and your beneficiary form says another, the beneficiary form may control for that account. Which is why reviewing beneficiary designations is one of the least exciting and most useful things a person can do. It is the kind of task that feels too small to matter, right up until it matters tremendously. So from time to time, it helps to review account beneficiaries, especially after marriage, divorce, births, deaths, or major life changes. Quietly, methodically, preferably with tea. Part 5. Trusts, the mysterious siblings of wills. Now we come to trusts. Trusts often sound complicated, partly because they are called trusts, and partly because people lower their voices when they mention them. But the basic idea is simple. A trust is a legal arrangement where one person or institution holds and manages property for the benefit of someone else. There are many kinds of trusts, but one commonly discussed type is the revocable living trust. A revocable living trust is created during your lifetime. You may act as your own trustee while you are alive and well. You can often amend it or revoke it during your lifetime, hence the word revocable. Then, if you become incapacitated or after you die, a successor trustee can step in and manage or distribute the trust assets according to the instructions you set. People use living trusts for different reasons. They may want privacy. They may want continuity of management. They may want to avoid probate for assets properly titled in the trust. They may own property in multiple states. They may simply enjoy a nice binder with tabs. But here is the crucial sleepy detail. A trust only controls assets that are actually in the trust, or otherwise directed to it. This means the trust must be funded. Funding a trust means retitling certain assets into the name of the trust, or coordinating beneficiary designations where appropriate. Without funding, a beautifully drafted trust may sit there like an elegant but empty picnic basket. Stylish, impressive, not especially useful in the moment. So the trust document matters. And the funding matters. The funding matters so much. If you are becoming drowsy, that is understandable. Trust funding has that effect on many people. Part 6. The pour-over will. Many people with a living trust also have a pour-over will. A pour-over will is designed to catch assets that were not transferred into the trust during life and direct them into the trust at death. It is like a final, gentle sweep, a soft administrative funnel. It says, essentially, if I forgot to move something into the trust, please pour it over there now. This may still involve probate for those particular assets, depending on the circumstances. But it works together with the trust as part of the overall plan, like matching socks, or two very polite accountants. Part 7. Incapacity planning. Estate planning is not only about what happens after death, it also includes planning for incapacity. Because sometimes the most important question is not who gets what. It is who handles things if I cannot. This is where documents like the durable power of attorney and the healthcare directive become important. A durable financial power of attorney usually authorizes someone you choose to handle financial and legal matters for you. That may include paying bills, managing accounts, handling real estate matters, signing documents, or dealing with government benefits, depending on the document and the law. The word durable usually means it remains effective even if you become incapacitated. This person is often called your agent or attorney in fact, not necessarily a lawyer, just your chosen representative. Choose someone trustworthy, someone competent, someone unlikely to view your checking account as a whimsical group project. Then there is the healthcare power of attorney or medical directive, depending on the state. This typically names someone to make medical decisions for you if you cannot make them yourself. It can also work alongside an advance directive or living will, where you express preferences about certain medical treatments and end-of-life care. These documents matter deeply. They can guide loved ones during stressful moments. They can reduce uncertainty, and they can help ensure that your preferences are known, which is one of the most meaningful gifts planning can provide. Part 8. HIPAA, the Sleepy Gatekeeper. Now, a brief visit to HIPAA. HIPAA is the federal law that helps protect private health information. In practical estate planning terms, people often sign a HIPAA authorization so designated individuals can access medical information when needed. This can matter because sometimes a loved one is trying to help, but the hospital says, in effect, "We appreciate your concern, but no." A HIPAA release can make communication smoother, and smoother communication with institutions is one of the hidden themes of estate planning. Another hidden theme is, please write this down somewhere. A third hidden theme is, update your documents. We will come to that, softly, eventually. Part 9. Guardians for minor children. If you have minor children, naming guardians in a will can be one of the most important parts of an estate plan. This is where you state who you would want to care for your children if both legal parents are unable to do so. Courts still have a role, and local law matters, but your nomination can carry significant weight. This decision is often emotional. You may think about values, stability, location, age, health, parenting style, existing relationships, and whether the prospective guardian has ever said the phrase, "bedtimes are kind of optional." You may also think about money. The person who raises a child does not always have to be the same person who manages money for the child. Sometimes families separate those roles. Sometimes they do not. The right answer depends on the family, the people involved, and the laws of the state. And as we drift deeper into our administrative meadow, remember, clarity now can spare others impossible guesswork later. Part 10. Special considerations for pets. And now, because no sleepy discussion is complete without pets, what about the animals? Pets are beloved family members. Legally, though, they are often treated as property, which is rude, but true. Estate planning can address who should care for your pets, and in some cases, funds can be set aside for their care. Some jurisdictions allow pet trusts. A pet trust can provide money and instructions for things like food, veterinary care, routines, medications, and perhaps the very specific requirement that Mr. Biscuits is to be addressed respectfully at all times. You may also leave detailed care notes, favorite foods, medical needs, behavior quirks, the exact location of the emergency treats. This is excellent planning. And frankly, many pets have stronger opinions about routine than the average human beneficiary. Part 11. Personal property memorandums and sentimental items. Money matters, real estate matters, but sentimental items can cause surprisingly intense feelings. One lamp, one ring, one recipe box, one collection of holiday ornaments. Sometimes the smallest objects hold the largest stories. Some plans include a personal property memorandum, where permitted by law, to list who should receive certain tangible items. This can be easier to update than redoing a whole will every time you decide who should receive the antique mirror or the quilt or the mysteriously important wooden spoon. The more specific you are, the better. Divide my belongings equally sounds peaceful. Until three people all believe they were promised the same painting. Specificity is soothing. Specificity is sleep. Part 12. Digital assets, passwords, and the modern afterlife of subscriptions. Now we enter the glowing, password-protected realm of digital assets. These may include email accounts, cloud storage, social media accounts, digital photos, online banking, reward points, domain names, subscription services, cryptocurrency, and the streaming account somehow shared by half the extended family. Digital estate planning matters more and more. It helps to keep an inventory of important accounts, devices, and access information in a secure place. Not necessarily in your will, which may become part of a public probate file, but somewhere secure and accessible to the right people. That might be a password manager, a secure document, a letter of instruction, a safe inside a safer safe. Whatever works. You may also want to leave instructions about what should happen to digital accounts. Should social media be memorialized or deleted? Who can access photos? Who should manage an online business? Who knows where the two-factor authentication codes go? The modern person may have fewer paper files than previous generations, but infinitely more passwords. And estate planning now includes preparing for the possibility that no one else knows how to unlock the small glowing kingdom you maintained from your phone. Part 13. Letter of instruction. Not every useful document is a formal legal document. A letter of instruction is often an informal document that can accompany your estate plan. It may include practical details like where important documents are stored, who to contact, funeral or memorial preferences, account information, care instructions for dependents or pets, and any other practical guidance. It may also include gentle messages, helpful explanations, bits of family history, requests about personal items. It is not usually a substitute for legal documents, but it can be deeply useful. Think of it as the human voice alongside the legal framework. The legal documents say, "Here is the authority." The letter says, "Here is what would help." One speaks in law, the other speaks in kindness. Both are lovely. Part 14. Beneficiaries, contingent beneficiaries, and the importance of backup people. Whenever possible, name backup people, backup beneficiaries, backup agents, backup trustees, backup guardians. Because life is unpredictable and plans work better when they have depth. A primary beneficiary is first in line. A contingent beneficiary is the backup if the primary beneficiary cannot inherit. This matters more than people realize. Forms are often completed once and forgotten for years. But life changes. People move. Relationships shift. Someone named in a document may die before you do, become unable to serve, or simply prove to be the sort of person who should absolutely not be in charge of anything with a signature line. Updating backups is wise. Backup people are the spare batteries of estate planning. Quietly essential. Part 15. Taxes, briefly and drowsily. Now taxes. Do not be alarmed. We will keep this soft. Depending on the size of an estate and the jurisdiction, taxes may or may not be a major issue. There can be federal estate tax considerations for very large estates. Some states have their own estate or inheritance taxes. Income tax issues may also arise for heirs or estates. Rules can be highly specific and may change over time. For many people, taxes are not the central reason to do estate planning. Organization, clarity, incapacity planning, and ease of administration may be more immediate priorities. But for some households, tax planning is a significant piece of the puzzle, especially with larger estates, business interests, investment property, or complex family structures. This is one of those areas where professional advice can be especially helpful. And now, let the word basis drift past you like a cloud. Let the phrase "step up in basis" float across a moonlit lake. Do not chase it. Let it go. Part 16. Blended families, businesses, and other layers of complexity. Some estate plans are fairly straightforward. Others involve blended families, second marriages, stepchildren, family businesses, rental property, special needs planning, charitable giving, asset protection concerns, or property in multiple states. In those cases, details matter a great deal. For blended families, for example, people may want to provide for a spouse while also preserving assets for children from a prior relationship. Business owners may need succession planning. Who takes over? Who can sign? Who owns what? What happens if one owner dies or becomes incapacitated? Families supporting a loved one with disabilities may consider planning tools designed to preserve access to benefits while providing supplemental support. Charitable goals may involve outright gifts, beneficiary designations, or more specialized planning. Complexity is not bad. It just means the plan should match reality. A good estate plan is not a generic stack of papers. It is a map. And good maps acknowledge rivers, hills, weather, and the one relative everyone avoids discussing until dessert. Part 17. Updating the plan. Now we arrive at one of the quiet truths of estate planning. Making the plan is not the end. Updating the plan is part of the plan. Review your documents after major life events: marriage, divorce, birth, adoption, death of a loved one, a move to another state, major changes in assets, changes in relationships, changes in health, changes in who you trust, changes in whether your chosen executor still understands how email attachments work. Even without major life changes, periodic review is wise. Documents can become outdated. Contact information changes. Laws change. People change. The plan should still reflect your wishes. A dusty, forgotten estate plan is better than nothing, but a current estate plan is much better. It is fresh, intentional, ready, like clean sheets, but for legal preparedness. Part 18. Where to keep everything. Once documents are prepared, keep them somewhere safe but accessible. Not so safe that no one can find them. Not so accessible that they end up beneath a stack of expired coupons. Tell the right people where the originals are. Tell your executor, tell your agent, tell your trustee, tell someone responsible. A safe deposit box may or may not be ideal depending on local law and practical access issues. A fireproof home safe may be useful. Digital copies can also help, though originals may matter for some purposes. The key idea is this: the best plan in the world is less helpful if no one can locate it. Estate planning is, among other things, a battle against preventable confusion, and labeled folders are noble weapons. Part 19. Common mistakes. Let us now yawn our way through a few common mistakes. 1. Doing nothing at all. This is the classic. 2. Creating a will and assuming everything is handled. Sometimes it is not. 3. Forgetting beneficiary designations. A small oversight with surprisingly large consequences. 4. Creating a trust and never funding it. The elegant empty picnic basket returns. 5. Choosing the wrong people for important roles. A kind person is not always an organized person. An organized person is not always a wise person. A wise person may live 3 time zones away and never answer their phone. 6. Failing to update documents after major life changes. 7. Failing to communicate enough. Not every detail needs to be a family roundtable, but complete secrecy can create confusion. 8. Neglecting incapacity planning. 9. Forgetting digital assets. 10. Assuming estate planning is only for older people. In truth, any adult can benefit from some basic planning. Because adulthood is, among other things, a series of increasingly sophisticated folders. Part 20. The emotional side of planning. Estate planning is practical, but it is also emotional. It asks people to imagine difficult possibilities, to choose trusted decision makers, to think about death, incapacity, family dynamics, fairness, memory, obligation, and love. That can feel heavy. But many people feel relief once they begin. Because uncertainty is often heavier than planning. Planning creates shape. It turns vague worry into decisions. It turns avoidance into action. It turns "someone should really figure this out" into "this has been handled." And that is deeply calming. Even now, as your eyes grow heavier and the words transfer on death deed begin to sound less like a legal tool and more like a lullaby from an unusually responsible universe, you may feel it, the strange comfort of preparedness, the peace of having named the people, organized the papers, clarified the wishes, labeled the folders. Part 21, a gentle summary, so let us rest for a moment in what we have covered. Estate planning is not only for the wealthy, it is for anyone who wants to make things easier for others and clearer for themselves. A will can name beneficiaries, an executor, and guardians for minor children. Some assets pass by beneficiary designation or title outside the will. A revocable living trust can help manage and distribute assets, but only if it is properly funded. Powers of attorney and healthcare documents help with incapacity planning. HIPAA releases can help loved ones access medical information. Letters of instruction can provide practical guidance. Pet planning matters. Digital assets matter. Updating documents matters. Storing documents well matters. Choosing the right people matters very much. And through all of it, the goal is simple: clarity, care, and fewer frantic searches through drawers. Part 22. Drifting off with administrative confidence. Now, as we come to the end of our sleepy journey through estate planning, let the phrases wash over you one last time. Executor, trustee, beneficiary, durable power of attorney, advance directive, personal representative, contingent beneficiary, funding the trust, letter of instruction, transfer on death, guardian nomination, HIPAA authorization. A soft rain of terminology, a blanket of procedural foresight, a pillow made of labeled envelopes. You have done enough for tonight. No need to solve every legal question before sleep. No need to reorganize your filing cabinet at this exact moment. No need to rise from bed and review your retirement account beneficiaries by the glow of your refrigerator light. That can wait. For now, just rest in the idea that planning is possible, that clarity can be created, that even serious topics can be approached gently. One document, one decision, one labeled folder at a time. And somewhere, in the distance, a responsible adult places a signed healthcare directive into a fireproof box, and then goes to bed. Sleep well, dream peacefully, and may all your important papers be exactly where they are supposed to be.